under our Canadian Charter of Rights and Freedoms, under Section 10B, you have the right to retain and instruct counsel without delay upon arrest or detention. What does this mean, really? And in a nutshell, let's say you're arrested for sexual assault. So upon arrest, the police are going to read to you from a card that you have a right to essentially phone a lawyer. So they're going to bring you back to the police station and process you. And they're not supposed to, if you ask for a lawyer, you could say no, you could waive that right. But if you ask to speak to a lawyer, they have to make reasonable efforts as much as they can to put you in touch with a lawyer. They can put you in touch with a lawyer of your choice, which is a private lawyer. There's also 24-hour free legal aid duty counsel. It's a 1-800 number. So you're entitled to that. And that lawyer, if you ask for one, duty counsel is just fine to ask for example, you're going to be able to speak to that lawyer and get legal advice before you go into an interrogation room, before you give a breast sample, before you give some sort of DNA, anything like that. They're going to speak to that lawyer. That lawyer, in many cases, for example, in a sexual assault or domestic assault or DUI for that matter, in a DUI, they're going to tell you to provide the breast sample, otherwise just shut up and exercise your right to remain silent. Same with the sexual assault domestic. Do not say anything more to the police. Just be polite, but don't discuss anything about the case and don't do a statement. So the vexing question is, are you just entitled to one phone call? Well, in many situations, after you've talked to that lawyer, that's your call. The right's been exercised. But when are you allowed a second phone call? Well, there's two situations, and a case called Sinclair from the Supreme Court of Canada talks about this. The first situation is if there's been a change in jeopardy, in your jeopardy. So for example, at the time of your arrest for sexual assault, for example, they arrested you for one count of sexual assault on a victim, and they told you about that. And you speak to a lawyer, the lawyer told you not to say anything, but you're talking in the interview room and something arises or more information comes to them. They want to give you a lie detector test. Well, now you're facing a change in jeopardy. You shouldn't do the lie detector test, by the way. Or they want to upgrade the charges. They want to add more victims in the interview room. Here is the change in jeopardy. They have to reread your rights to counsel again, give you another opportunity to consult with a lawyer. So that's your second lawyer. So normally you just get one, but if there's a change in jeopardy, something that's going to affect you, change your circumstances rather than the original charge, lie detector tests, upgrading charges, they want you to provide hair analysis or something like that, or DNA that, it's a change in jeopardy. Now, what's another situation? Well, if there's something that comes to the attention of the police that the legal advice you received was deficient or you didn't understand it, they also have to give you a right to consult with another lawyer in that situation. So, and the only way that's going to happen really is if you tell them, look, I didn't really understand that lawyer. I was nervous at the time. They were speaking quickly. They had an accent. I didn't understand them. They weren't a criminal lawyer. I didn't get good legal advice. If you clearly explain that to the police, they have an obligation to provide you with a second consult. And really, I honestly tell people, look, just phone duty counsel. They're very good at this. You can speak to your private lawyer later. You're probably, it's rare that you can get a hold of your own lawyer at 3 in the morning. Duty counsel's available. They're going to give you the same advice as your private lawyer. Heck, if you want to speak to your own lawyer, great. Maybe they're going to wake up at 4 in the morning, but I often see situations where they don't, or they don't answer the call, or they're on vacation, and the person goes ahead and give a statement when they should have spoken to duty counsel, but they were insistent about their own lawyer. So don't be afraid to contact duty counsel. Hey, heck, try and speak to your own lawyer too, but default to duty counsel if your own lawyer is not available. So those are the situations where you're entitled to a second consult with a lawyer. I guess I could even envision third consults where your jeopardy changes again. I'm not sure if I've seen a case like that. There might be a couple in Canada where that's actually happened, but it often arises. And I've won cases, I've got statements thrown out and procedures thrown out, and where the police should have recognized there was a change of jeopardy. They were told or intimated at least that by the client that it was deficient legal advice, I want another lawyer, or they were implying that, and the police screwed up and we get the statements thrown out. So this is a very live issue in Canada, and this is all about rights to counsel and whether you're entitled to a second consult with a lawyer during the process of arrest and speaking to the police. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.